Ahora pasaríamos al siguiente.
We'll now move on to the next item, item 7, petition 70/2000. Imre Juhász, Hungarian citizen, bearing 2 signatures on a request for the repeal of Resolution 1483/2007 of the Slovak National Council concerning the inviolability of the Beneš decrees. The petitioner is not present, but has sent a document in Hungarian available to all MEPs. We'll start by giving the floor to Mr. Depagne from DG Just, the Commission.
Sorry, I'm sorry. The petitioners, they are here with us. So I'm going to give 5 minutes. First, welcome to them. And I'm going to give 5 minutes for Mr. Imre Juhász.
Mr. Imre Juhász, please press the speak button.
Yes. Can you hear me?
Yes, perfect.
Yes, thank you, dear Madam Chair. First, the co-author of the petition, Alida Zajdl, would like to speak, and I would like to have a 2-minute reaction at the end of the case, if this is in line with the Commission.
Yes, of course. At the beginning, you are going to have 5 minutes between you and Alida Han. You are today 2 petitioners, and then at finishing, when you are going to listen the Commission and all the groups, you are going to have 2 more minutes. So 1 minute you and 1 minute your colleague. Okay. So thank you very much. Go ahead. You have 2 minutes and a half, and then the another petitioner 2 minutes and a half more. Thank you very much.
Please, you can speak. Mr. Juhász, please press the speak button.
Okay.
Because perhaps I didn't understand you. You want just to speak at the end, not now at the beginning.
Not at the end.
At the end. Okay, perfect.
At the end, and firstly, Alida Zajdl.
Oh, okay, perfect. Okay, we're going to give the floor to you at the end. Now I'm giving the floor to Ms. Alida Han Zajdl for 5 minutes, because your colleague, he didn't take his time in that moment, so you have 5 minutes if you want, of course. Okay, welcome. Thank you very much. No, we cannot hear you. We can see you, but we cannot hear you.
Could you please activate your micro, Ms. Han?
Can you hear me?
Yes, perfect.
Good morning, Madam Chair. I would like to my speech in Hungarian. Tisztelt elnök asszony, tisztelt
Madam President, we're talking about the decrees of Eduard Beneš, 143 decrees. Out of these, 20 dealt with Hungarian minorities. 13 are of discriminative nature, and these are like laws used against Jews. For example, taking away their citizenship, confiscating their properties, or sending people away from work, not giving them pensions, or confiscating their bank deposit, freezing of bank deposits. The fundamental infringements in regards to the Beneš decrees are caused by the fact that the Slovak National Council in its resolution of the 20th of September 2007, as a member of the European Union, adopted a resolution number 533, in which it was determined that the totality of the decrees were unquestionable, untouchable, and unchangeable. With the act of the resolution being adopted in 2007, these documents have been reactivated and have been enforced, and their legal existence continued to this day. The argument which indicates that the Beneš decrees appear to be of the past and a historical issue lacks credibility, since the decision adopted in 2007 does not fall outside the temporal scope of the EU law, or rather it is about a legal standard which can be endorsed in particular cases, or it may be used applied in the context of enforcement. In the context of a number of restitution trials, Slovakian courts take decisions using the decrees where those affected are discriminated against. A judgment was confirmed for the first time by the European Court of Human Rights on 19th of May 2020 in the Bosic versus Slovakia case, application number 75041/17. We've submitted this document to you in English. According to these, the subsequent argument of the Slovak Supreme Court jeopardizes legal certainty. Another case was reported in the media in June 2020, according to which the Slovak State Land Fund, in many cases referring to the Beneš decrees, wishes to act in the expropriation procedure in connection with the construction of the D4 motorway. These topicalities also prove that, with reference to the decrees, decisions that violate the fundamental rights of the persons concerned and are still made today in administrative and judicial proceedings on the basis of severely discriminatory ethnic and national affiliation. As the European Commission stated in its answer to a written question adopted in a member state, legislation adopted in a member state before its accession to the Union and which are incompatible with the provisions of the Union law should be amended in order to respect the achievements of the European Union. Furthermore, the Commission made it clear that the return of confiscated assets constitutes a movement of capital as inheritance, and the prohibition of discrimination on grounds of nationality must also apply here. This was also confirmed by URI in its opinion on our petition on the 26th of June 2013. Klaus-Heiner Lehne said, as regards the legal situation arising from the regulations, judicial and administrative proceedings in existence, it may be desirable within the framework of the Slovakian legal system to further address the situation and influence of the regulations and the related legal provisions through legal examination of the law. According to Article 18 of the Treaty of the Functioning of the European Union, any discrimination on grounds of nationality shall be prohibited. We would also like to suggest that the Petty Committee seek the opinion of the European Commission, taking into account the judgment of the European Court of Human Rights referred to. This is what our petition points out, which is that a member state of the European Union, in this case Slovakia, has adopted and continues to adopt an infringing decision in its legal order, which is also part of common European law, thus opposing EU law and the common European value system. We believe that everything that inhibits or hinders the European unity must be abolished. As long as these decrees are in place, human rights, property rights are being violated, and moreover, the legal system as a whole is in conflict with the European Union legal system. In a state where the rule of law prevails, they should be repealed and not be a basis for verdicts. So we need deregulation. The Committee on Petitions could bring a case with a prominent European dimension to a success. Thank you very much for having listened to me.
Thank you very much. Now I'm giving the floor to Mr. Depeng of the Department of Justice of the European Commission.
Can you press the speak button, please?
Hello. Can you hear me?
Yes.
Yes, perfect.
Can you hear me? Okay. 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 Thank you, Chair. I was saying that the petition is raising important issues in terms of fundamental rights, rule of law as well, and the latest case from the European Court of Human Rights was about the issue of the justice system in Slovakia. So we don't deny the importance of the issues. However, the first point I would like to make is that the Commission and the EU institutions are competent to act only within the limits of Union law, and that the Charter of Fundamental Rights, which protects the right of property, the effective remedy before the courts, all these principles are enshrined in the Charter of Fundamental Rights of the European Union. However, the Charter is applicable only within the scope of European Union law. And I think our position in our replies to this petition have been clear that the issue at stake, the Beneš decrees and the acts which were taken after the Second World War are prior to the accession to the European Union, and as such, they fall outside the temporal scope of EU treaties and are acts which were taken before the EU treaties, even if property rights issues continuing legal effects in the future, acts themselves were in the past. So that's our position, is that these acts we are falling outside the scope of Union law. We have taken note and we have seen the recent development, the court case before the European Court of Human Rights, but we maintain our position that this is a dispute which has to be settled, and property disputes of this kind and issues relating to rule of law are, as far as we are concerned, issues for national competence. And of course, we expect national principles from their own constitution, as well as European Court of Human Rights jurisprudence and judgments. And when we talk about rule of law, this means independence of the judiciary, proper functioning of the judiciary at national level, but also respecting and implementing correctly the judgments of European Court of Human Rights. But again, these are comments I make on matters which are not falling within the scope of Union law, and it's the national European obligation of the sovereign chair.
Now I'm going to give the floor to Logan Vince of EPP Group.
Gracias, Presidenta.
Dear colleagues, we're talking about wounds that are decades old. We are talking about the Beneš decrees. And we have already discussed this issue before the accession of Slovakia. And this is not the first time we talk about this issue here in the Petitions Committee. However, there's no progress, at least not on EU level. Let's not forget that, as the petitioners said and explained, and I thank them for keeping this issue open, and I also thank them for their patience. So, as they said, in 2007, and the Constitutional Committee of Slovakia reiterated that the Beneš decrees are inviolable. So I do have to call your attention to this fact. This is not a moment in time that would be preceding the accession of Slovakia to the EU, but we're talking about 2018. As for the Beneš decrees, The problem with these decrees are the following. There are 13 decrees and decisions that actually establish collective guilt based on ethnic background. This concerns Germans and Hungarians. And this is what we need to talk about, because this collective guilt was reiterated by the National Assembly. This decree is not part of history as yet. As we have heard in past months, there have been several cases showing that these are not dormant decrees. They are very much alive, because they validate confiscation of properties. For example, the land fund sued persons referring to the Beneš decree, trying to confiscate plots around Bratislava, where they are trying to build a motorway, the D4 motorway and highway ring. So there is no compensation offered by the state. Instead, the state refers to a decree dating from 1945. Therefore, they are exempt of compensation. And this is all based on ethnic background. So the only reason for this to be possible is that they are Hungarians. So I don't agree with the arguments of DG Just. We have to talk about rule of law here. But he says that we cannot do a lot because we are talking about a minority issue. No, there are no double standards to be applied. Either this fits into the EU law or not. Either this violates property right or not. Either we uphold rule of law or not. We cannot do cherry picking here. I don't think this is right. So the URI committee has also dealt with this issue. Actually, it dealt with this issue in 2014. And they said that these events violate the free movement of capital. And this we have heard from the replies of the Commission as well. So now let's look into this issue. I believe that the Petitions Committee must offer help to these persons. Let's take a wider look at this. Our committee has offered help in previous cases as well. And now we are talking about a Hungarian minority of 500,000 people, and talking about collective guilt with respect to this minority is just not right. And here the president interrupts the speaker. So the final remark, I suggest that this petition must be kept open. However, we ask the committee to look into this issue in detail. So we need an expert opinion. Of course, we need the opinion of the Slovak government as well, because there have been changes. So let's listen to them as well. We need to see specific measures taken. And we can also refer the issue to the Committee of Rule of Law, or we can have a visit. We can organize a visit to Slovakia as well, because these issues come back again and again. And I also suggest that we should talk about this issue here again at a later point of time. Thank you very much for your patience, Madam.
Yes, so much. Just one question, Mr. Vince. You are asking us to maintain open and to do an evaluation. But this evaluation, who has to do it for you? The Commission or some committee here in the Parliament?
There are several ways. I would propose that we ask the European Commission to make a more thorough assessment on this case, but we also ask the opinion of the LIBE Rule of Law group and ask also the opinion of the Slovak government through the permanent representation so that they present their position, and then we can come back to this in the committee, perhaps organizing a fact-finding visit and then coming back on the agenda. Thank you.
Okay, thank you. But you know that the finding mission, the coordinators, they have to ask it in the coordinator meetings, not today. So, okay, thank you very much. Mr. Zlotowski of ECR has the floor.
Buenos días, señora presidenta. Cóż, dekrety Benesza to jest prawo, które...
The Beneš decrees are laws which are quite old and date back to the end of the Second World War. We are still feeling the effects of the actions of King Carl Gustaf in the 17th century. The fact is, there is Polish real estate which is in Swedish hands because it was effectively stolen at that time. This is a problem for us when we are looking at the results of various armed conflicts on the territory of the contemporary European Union. I'm in favor of closing this petition. This is a conflict which should be resolved in Slovakia on the basis of Slovak law. Thank you.
Thank you very much. Now, Mr. Kosa.
Thank you very much, Madam Chair. Yes, I have looked into this issue in detail, and as a lawyer, I'm really interested in this. So let me just offer you a summary. When you say Magyar, Hungarian, it's a very sensitive issue. We are talking about the collective guilt of the Hungarian minority. So we need all parties to come together and we need the European Union to mediate. I believe that we cannot consider the decrees to be a historical act. In its letter in 2014, the URI committee says that these decrees are valid from a judicial point of view. The cases mentioned here, the case of Bušić versus Slovakia, well, in this case, the Slovak State Forest Company confiscated the property of a Hungarian person, of Mr. Bušić, who owns 35 hectares in northern Slovakia. After the accession of Slovakia to the EU, there was a legal case opened in 2009 by the Slovakian state saying that Mr. Bušić cannot be the owner of these lands because these lands should have been confiscated from the grandfather of this person in 1946 because they were of Hungarian origin. The courts did not find this decision valid, and the Constitutional Court decided that the case was dealt with properly, so the rights of Mr. Bosic were not violated. The ECHR reinforced this decision in 2020, and this is of crucial importance because on an international level, this was the first time when we actually stated that on behalf with respect to the Beneš decrees, properties are being confiscated. So we are talking about a document that came to life before the accession of Slovakia to the EU, and they are still using these decrees to take decisions on state level today. So yes, we are the valid forum, the competent authority to deal with this issue. So I'm asking the same thing as my colleague from the People's Party. I want this dossier to remain open, and I want the European Commission to have a deeper look into this issue. And we should also refer this to the LIBE committee and ask for their opinion. And I also would like to have a fact-finding mission carried out in Slovakia. This is our common issue, and it needs to find a common solution. Thank you.
Now I'm giving the floor to Ms. Danoka, Greens Group.
Yes. Do you hear me?
Yes, perfect.
Yeah. So my greetings to everybody. And about this particular petition, I have to say that in my experience, it is the third time we are speaking about Beneš decrees. But this time we have a good reason to do this, since there is a court decision, European court decision, fresh decision of last year, 2020, Bosic versus Slovakia. And this gives us just arguments to examine this petition, and our proposal is also to keep it open, since the reply of the Commission, just based on famous Article 51 of the Charter, that is, we all know, reference to competence of the European Union. It is a discussion taking place all the time on this Article 51, and we insist that cases of violations of human rights, and in this case it is applied to ethnic groups. To ethnic groups, it's collective punishment, which is by the Charter not permitted. So we have to rely on the Charter and to ask Commission to deeper examine this case, and taking into account the ruling of the European Court of Human Rights. That's our proposal. Thank you.
Thank you very much. Peter Jahr, do you want the floor? Because yesterday you asked us to take the floor. We saw you that you are connected, but...
Mr. Jahr, could you please press speak button?
Oh, Entschuldigung.
Okay.
Hallo, Entschuldigung, ja.
Yes, I'm sorry about that, and good morning to everybody. I agree with Vincent Lawrence. This is not about legislation before accession. This is following accession. The Beneš decrees are still being used, and this is not acceptable. The Commission must draw this distinction. I agree with the colleagues from my group. This petition should remain open, and the committee responsible should also deal with it. The problem is the Beneš decrees are still being implemented today, and that is not acceptable. And I do apologize for my muddle at the beginning.
Now I'm giving the floor to conclude the petitioner for 2 minutes, Mr. Imre Juez.
Can you hear me?
Yes, we can hear you.
Yes.
Thank you, dear Madam Chair, dear members of Committee on Petitions. Thank you for the opportunity to give a short comment in the present case. I would essentially like to address an argument that often arises in connection with the controversial Beneš decrees. This statement says that the decrees are historical acts without continuing legal effects. Let's look at this question briefly. We have presented 2 examples to prove that there is no question of legal history. Similar examples could be listed for hours. Ms. Alida Hanzedl and Mr. Vince and Mr. Kosha mentioned first of all the case of Bosic versus Slovakia, which was decided by the European Court of Human Rights in 2020. The court found the violation of the fair trial and established the facts that, I quote, in 2009, Mihaj Bosic was sued by the Slovak State Forest Company, and the Supreme Court given property should have been confiscated from them, according to the Supreme Court, in order to preserve the necessary authority of the state. It should be treated as if the property had been confiscated. No comment, I think. Not necessary. Just 1 month after the Bosic decision, another case has been revealed where the Slovak state, precisely the Slovak Land Fund, wants to confiscate 60 plots worth millions of euros under the D4 highway near the recent Slovakian capital. Bratislava, Hungarian name is Pozsony, again on the basis of the Beneš decrees. Following this, I hope no one believes that the incriminating Beneš decrees are part of the legal history. In our view, this is a serious issue of the rule of law, to which, as we all see today, the European Union is very sensitive. We would kindly like to ask the Honourable Committee to carry out a substantive examination of the petition, as this has essentially not yet happened. We would like to draw your attention to Article 18 of the Treaty of the Functioning of the European Union. I quote, "Any discrimination on grounds of nationality shall be prohibited." I would like to draw your attention to our recent evidence. And final conclusion. This is not a Slovak-Hungarian debate, I think. This is not primarily a debate between Slovakia and Hungary. This is a debate about collective guilt, about collective punishment in the 20th century and the common Europe for the 21st century. Trusting in your wisdom, thank you for your attention.
Muchas gracias.
Thank you.
Hemos dado por concluida esta.
That brings us to the end of this petition item. We've listened to the petitioners, the different MEPs from various political groups, and the Commission. Our decision is to leave the petition open. We will ask the European Commission to update its information and to conduct a more detailed examination, taking into account the most recent ruling on this matter. Thank you to you all. Let's move on now to item 8. Petition 0354/2002, presented